Tecnimont S.p.A. and another, and LLC EuroChem North-West-2.
Yes, Mr Dunning.
My Lord, I appear for the appellant, EuroChem NW2, together with Mr Robb behind me. I've taken the place of Mr Millet, who argued the case below, who's unavailable for this expedited appeal. My learned friends Mr McLean, King's Counsel, and Mr Leary appear for the respondents. The appeal is made with the permission of Mr Justice Butcher, and it's an appeal, as you will have seen, against the grant of a partly mandatory and partly prohibitory anti-suit injunction made expressly under Section 42 of the Arbitration Act 1996, requiring compliance with anti-suit orders made by the tribunal.
Yes.
There is a single ground of appeal for which permission to appeal was granted, and that is to be found in Schedule 4. I expect you've looked at it, but it's Schedule 4 to the order under appeal, which is at Core Bundle, tab 5, page 44, and the ground of appeal is at page 50.1.
Yes.
And I can take your lordship to that if you wish, but I wasn't thinking it was necessary.
No.
So the ground of appeal raises a question of law, of statutory interpretation of sections 40 to 42 of the Arbitration Act 1996, namely whether the court has jurisdiction in the sense of power to grant an anti-suit injunction, whether in mandatory or prohibitory form, under section 42. And in my respectful submission, the court does not have such power under section 42, and the learned judge therefore erred in law in granting the order that he did under section 42. I won't say very much about the background, my lord. We have an agreed glossary of terms and names, which is at tab 3 of the core bundle, and an agreed chronology of events, which is at tab 4 of the core bundle, and the background is also set out in paragraphs 1 to 27 of Mr Justice Butcher's judgment, which you will have read. The reasons why we submit that there is no power under section 42 to grant...
Just before you get fully launched, can I just deal with questions of timing?
Yes.
It seemed to us that we ought to conclude the argument by 4 o'clock at the latest. We'd hope it might not take that long, but there we are. We also think that there are obviously disputes about section 37 as an alternative basis for jurisdiction, and it seems to us convenient, but tell us if we're wrong, to have the argument on both sides on section 42 first, and then deal with section 37 arguments separately.
Yes. Very well, my lord. My learned friend and I had agreed a provisional timetable, which was necessarily provisional because we knew that the court might have its own view.
Yep.
And so I will proceed accordingly. Under my provisional timetable, I was planning to open the appeal on section 42 in a roughly 1 hour and 30 minutes. Obviously, that depends on the number of questions, but in terms of my running time, I'm hoping to conclude those arguments in 1 hour and 30 minutes. So what I want to do, my lord, and you'll appreciate that the skeleton argument went in something of a hurry for the expedited application. And I have reduced the propositions on which we rely to 9 main propositions. And if I could just take a moment at the beginning just to set these out carefully, and then I'll go to the authorities in a little bit more detail, although there is really no authority which is bang on the point which is before the court. But the first proposition is this, that in arbitration law, there is a fundamental conceptual and terminological difference between, on the one hand, an arbitration agreement, which concerns a future process for the resolution by arbitration of either present or future disputes, And on the other hand, a reference to arbitration in the form of actual arbitral proceedings relating to a particular dispute. And that key distinction runs through arbitration law and is also reflected in the Arbitration Act itself. Secondly, an arbitration agreement contains both a positive covenant or obligation, namely the contractual obligation to submit disputes to the agreed form of arbitration, and a negative obligation or negative covenant, a contractual obligation not to submit disputes, falling within the scope of the positive obligation to a forum other than the agreed contractual form of arbitration. And in this area of law, an anti-suit injunction is granted to enforce that negative covenant in the arbitration agreement. And I would add, and it is common ground here, as I'll show you, that that was the basis on which the tribunal granted the orders in question in this case.
And in these submissions, when you talk about anti-suit, do you include anti-arbitration?
Yes. Yes. Include the mandatory part as well as the prohibitory part. Although there is a possibility that there could be a distinction, but my primary argument is there's no distinction between them. But there is a possibility that the court could take the view that there is a difference between the prohibitory part and the mandatory part. But that's not my main submission.
No, I understand. But you define the negative part as an obligation not to submit disputes to a forum other than the contractual forum.
Yes.
But I think you include within that an obligation not to seek relief from a foreign court to prevent the arbitration taking place, do you?
Yes, that would fall within it.
Because we are here concerned with not simply anti-suit in the classic sense, but anti-arbitration.
Yes. Can I reflect on the scope of the obligation and come back to you on that particular because that's a different point from the one that I had in mind, which is that it might be said that one form of injunction is necessary for the proper and expeditious conduct of the arbitration and the other isn't.
Yes.
But your lordship's question is one I hadn't anticipated, so perhaps I could reflect on that and come back to that.
All right. 3.
The critical distinction between arbitration agreements on the one hand and actual references to arbitration taking the form of a present arbitration or arbitral proceedings is recognised throughout the Arbitration Act, and I'll take you to the provisions of the Arbitration Act in a moment. The sections from sections 33 to 45 of the Act are, and this is really the fourth proposition, are concerned with actual references to arbitration. And in particular, the sections with which we are concerned, this is the fourth proposition, sections 40 to 42 are solely concerned with the conduct of actual references to arbitration. The key word in sections 40 and 41 is conduct of the arbitration or of the arbitral proceedings. And the conduct of an arbitration relates to how the particular arbitral reference is conducted. It follows in my submission that these sections are not concerned with the enforcement of either the positive or the negative obligations contained in the arbitration agreement. The fifth proposition is
Are they concerned with questions surrounding the enforceability of the award? Because Mr Millet's skeleton suggested that they were.
Are you using the word award in the sense of the arbitration?
Yes, the future award. You say this is all about conduct of the arbitration. Those are the critical words.
Yeah.
But does conduct of the arbitration in your submission include matters relating to the enforceability of the award? But I picked that up from Mr Millet's skeleton.
It doesn't, in my respectful submission. It means what it says. And I'll show you what the DAC report is. I come into this in another proposition. It relates to the functioning of the arbitral process. If I may, I'll move to the.
Yes, all right.
I'm sorry if I haven't.
I was just trying to find a passage in Mr Millet's skeleton. If that is what he said, you don't support it.
That's correct. Yeah.
The fourth proposition was concerning 33 to 45.
Well, 33 to 45, and in particular, sections 40 to 42.
That's four.
Which are the ones we're concerned with. All of 33 to 45 are concerned with actual references to arbitration, and sections 40 to 42 are solely concerned with the conduct of actual references to arbitration. So there were two propositions there, but it's rolled into one. The fifth proposition is that what I've said in the previous proposition, number 4, is supported by the fact that the entire Supreme Court, and I'll just interpose there, this is not a speech of Lord Mance, this is the judgment of the court, the entire court. No other Supreme Court justice said anything on this issue. So we say that the fourth proposition is supported by the fact that the entire Supreme Court held, as part of the ratio decidendi in the AES case, which I'll take you to, relating to section 44, that an anti-suit injunction cannot be granted under section 44(2)(e) because section 44 is related to a particular reference and is not concerned with the enforcement of the negative covenant contained in the arbitration agreement. And the key passage, and I'll take you to it in a minute, in the judgment of the entire court is paragraphs 46 to 48. The sixth proposition, moving on from and linked to that, is that in section 44, the relevant qualifying phrase which the Supreme Court held could not apply to anti-suit injunctions was the wording in section 44, subsection 1, and I quote, "for the purposes of and in relation to arbitral proceedings." That was the phrase that they held related to a particular reference to arbitration and not to enforcement of the arbitration agreement. And we submit that the court's reasoning in the AES case is equally applicable to the equivalent qualifying phrases in sections 40 and 41. And there they are almost identical. The relevant qualifying phrase in section 40, subsection 1 is, and I quote, "necessary for the proper and expeditious conduct of the reference." That's 40, subsection 1. And there's a virtually identical phrase in section 41, subsection 1, which is necessary for the proper and expeditious conduct of the arbitration. So in one it says the reference, the other says the arbitration. So we say those are equivalent to the phrase that was considered by the Supreme
Do you
Court.
say they're the same as, for the purposes of and in relation to arbitral proceedings?
No, I don't say
Or
that.
Do you
they're the
say you
same.
say they're narrower?
That's my next proposition.
Sorry.
But
Yes.
but I'm just saying that these are the equivalent or qualifying phrases. They're actually slightly differently worded, but just as the words in section 44.1 qualified the powers in section 44.2, so do the words in sections 40 subsection 1 and section 41 subsection 1 qualify what constitutes a peremptory order, which is then one that is capable of being enforced by the court under section 42. Now, obviously I'm going to address at some point my learned friend's argument, but just to interpose here in these propositions, my learned friend's argument is that sections 40 and 41 apply to any order, and they stress, and they've got a number of authorities stressing that they say any means any. So they say that the court can enforce under section 42 any order that the tribunal chooses to make. And in my respectful submission, that ignores three things. First of all, that these three sections, 40 to 41 and 42, are concerned with the conduct of the reference. Secondly, it ignores the qualifying phrases in section 40, subsection 1 and subsection 1 of section 41. And it also ignores the reasoning of the Supreme Court. And I'll come back to that in a moment, but I just thought it was appropriate to interpose that there. My seventh proposition is that the reasoning of the Supreme Court applies a fortiori, something I've already mentioned in answer to my Lord Justice Popplewell's last question. And the reason for that is because if the enforcement of the negative covenant in an arbitration agreement is not within the wide phrase, which is in section 44, subsection 1, for the purposes of and in relation to arbitral proceedings, it is impossible, in my respectful submission, to see how it can be within the more restrictive and narrower phrases in sections 40 and 41, which expressly state that orders within section 41, and hence within the court's power under section 42, must relate to the actual conduct of the arbitration and must be necessary to make such conduct of the arbitration proper and effective. The word is expeditious, but proper and expeditious. So therefore, we say that the court's power under section 42 is limited to orders made by the tribunal which relate to the actual conduct of the arbitration and which assists the internal functioning of the arbitration. And if the court, if a tribunal makes an anti-suit order, it is not something that the court, on the true interpretation of these three sections, can enforce under section 42.
We introduced the concept of internal functioning. What
Yes.
does internal functioning mean?
Actually, I don't really need that point, but I know that's the way it's been cast in the skeleton argument. Well, it's sufficient for me to say it relates to the conduct of the arbitration.
So if one of the parties is doing something externally that affects the conduct of the arbitration, then that will be court to.
Well, it would depend on what it was.
Trying to stop the arbitration.
Well, in my respectful submission, that doesn't affect the conduct of the arbitration, not ipso facto anyway. And as has happened here, the arbitration is continuing completely unaffected by the Russian proceedings.
Well, we need to be a little bit careful, I think,
I don't want to go into the facts, but
whether we address the argument by reference to particular facts, because
yes,
I think really your point is this is so as a matter of principle and holds good for any form of anti-suit relief, including, as my lord says, anti-arbitration relief.
yes, I do. I mean, I have an alternative point that it even if it applies to anti-arbitration relief, it doesn't prohibit the proceedings on. It doesn't apply to the order the tribunal made in relation to the proceedings on the merits in Russia. But my broad point is it doesn't apply to it doesn't give the court power to order either. Under section 42, there's always section 37 potentially available. And entirely take my Lord or Justice Phillips' point that the word internal doesn't appear in the Act, and it doesn't appear in the DAC report, which I'm coming to as my 8th proposition. So, but I don't need that. I don't need the word internal, because conduct of the arbitration. What is? I mean, it is. I mean, the relevant words, just pausing, are necessary for the proper conduct or the expeditious conduct of the arbitration. Now, how in the abstract does an anti-suit injunction, how can it be said to be necessary for the proper and expeditious conduct of the arbitration? Arbitration, I think reference is used in one of the other, more or less the same. So my 8th proposition, moving on, is the previous submission is supported by the DAC report, which is admissible as an aid to interpretation. And I'll take you to that. It's not very long. But it describes the purpose of the new power created by section 42. And the phrase that it used was that it was to, and I quote, assist the proper functioning of the arbitral process. And in this, my submission shows that the power in section 42 is focused on the working or the functioning of the arbitral process itself, and not on matters external to it. And we'll see when we look at the DAC report, there's not a hint of a suggestion that it was a power intended to be exercised beyond or outside the reference to enforce the arbitration agreement by way of restraining other proceedings. And my 9th proposition is simply that it follows from the first 8 propositions that the court had no jurisdiction in the sense of power to grant the injunction that it did, and therefore the order should be set aside. So
Can I just see if I've understood the structure? There are 3 stages. There's the original order by the tribunal. There's then a peremptory order for failure to comply with the original order. and there's then the court order under section 42. I understand your argument that at stage 2, the power of the tribunal to make a peremptory order is limited in the way you've described. But you're not, I think, saying, are you, tell me if I'm wrong, that at stage 1, the tribunal had no power to order the anti-suit relief in a non-peremptory form?
Well, it's certainly not necessary for my argument for me to say that. And it's an open question whether it did. I mean, in this particular instance, we've got the ICC rules.
We've got Article 28. It's an interim and
It's an
interim or conservatory measure, isn't it?
It is certainly often interpreted as giving a tribunal the power, and it's not part of my argument for present purposes that the tribunal didn't have that power. I mean, I would, if the matter were to go further, I might reserve that point, but I don't. It's not.
Well, I'm not sure that's. I mean, there was a point taken before Mr. Justice Butcher that it didn't come within Article 28 because it wasn't interim, and that was rejected, and there's no appeal in relation to that.
No.
And speaking for myself, I'm inclined to think that if there were any other point that was going to be taken as to a lack of jurisdiction to make the initial offers, that would have to have been taken below and wasn't.
Well,
but anyway,
there we are.
Your argument.
I didn't appear below, and you've no doubt read the transcript, or you've got the transcript, and you can see what points were argued and weren't.
But you're content that your argument can proceed on the assumption
Yes.
that there was power originally to make the anti-suit orders which formed the original orders and directions.
The key point is whether that is capable of becoming a peremptory order
Quite.
under Section 41, which is capable of enforcement under Section 42.
Quite. Because the entirety of your argument proceeds on the basis it's only when you get to Section 41 that these qualifications come in. So it's only at the peremptory order stage, is that right? Yeah.
And this also, by the way, is, and it may have been my fault for the way I argued it in the Pearl case, I don't know, but why the reasoning of Mr. Justice Person is not apt, because he was focused on Section 40, not Section 41. And we'll come to that. Now, so those are the 9 propositions, my lord, and I won't spend too long on some of them. The first proposition, the conceptual and terminological difference between arbitration agreement and reference, that derives in particular from Lord Mustall's comments on Lord Diplock's speech in the Bremer-Vulcan case. It's in the case called Black Clawson. I suspect you're very familiar with it. It's in the authorities at tab 4, that's AB1 for the opus EPE operator, AB1 page 55. And the relevant passage is on page 63. Where he starts in the on the right-hand column, examining Lord Diplock's famous speech in the Bremer-Vulcan. I don't need to spend too much time on this. And then on the next page, having looked at that, he says, it is, I believe, clear, and this is the sideline passage, that there are not one but 2 sets of contractual relations which govern the arbitration disputes. First, there's this contract to submit future disputes, comes into existence at the same time as a substantive agreement of which it forms part. Prima facie run for the full duration of the substantive agreement and will then survive for as long as any disputes remain unresolved. Second, there are one or more individual sets of bilateral contractual obligations which fall into existence as and when one party asserts against the other a claim falling within the scope of the initial promise to arbitrate and have not been able to settle. And he refers to one as continuous agreement and the other as individual agreements, or what more commonly is called references or arbitrations.
So there are two sets of contractual obligations, albeit distinct. One is the arbitration agreement, and the other is what one might call the reference contract.
Yes, exactly. And not surprisingly, for example, if one goes to the new edition of Must and Boyd, third edition, which is heavily edited by Mr. Justice Foxton and his team, one finds, and I don't think I really need to take you to it, but references to the distinction between the continuous arbitration agreement, as analysed here, and a specific reference to arbitration, or an arbitration pursuant to the continuous agreement. And we submit that sections 40 to 42 here have to be construed with that distinction in mind. These sections 40 to 42 are concerned with the conduct of the specific reference to arbitration. They're not concerned with the continuous arbitration agreement. And it is obvious, and when we come to the Supreme Court in AES, that the Supreme Court was well aware of that key distinction and based its decision upon it, as one can see at paragraphs 46 to 48, which we'll come to in a moment. Then the second proposition, again, it should not be difficult or controversial. An arbitration agreement contains both a positive covenant and a negative covenant. If we just look very briefly at the third edition of Must and Boyd, which we have in Authorities Volume 3, tab 40, that's for the EPE operator, that's AB3/3844. Sure whether your lordships are operating from the hard copies or the EPE.
We're all on hard copy.
You're all on hard copies, and that's fine. Yes, that's a bit easier. Then perhaps that just for everyone else that we could catch up with EPE operators, AB3/3, page 844. And if we could look, please, at page 850. There's a section on what is page 110 in the textbook, paragraph 3.139, and it talks about distinct obligations.
On the screen.
Yes, well, I don't know why it's not on screen. I've asked for it twice now.
There isn't page 844, apologies, in the electronic bundle.
Right, okay.
But don't worry, we're all working on paper, and I think we've all got it. So
Yeah.
it may be
There isn't.
inconvenient for everybody else, but it's not for us.
Well, that's very good. I'm glad to hear it. So anyway, you can see the second bullet point in 3.139, B promises to A that if A has a claim which falls within the scope of the agreement, B will enforce that claim only by means of a reference to arbitration. And then at paragraph 3.141, it says, so far as the second obligation is concerned, it has been noted that implicit within it are two covenants, one positive in content, one negative. Positive obligations undertaken by a party seeking relief within the scope of the arbitration agreement to do so in arbitration of the agreed kind, and the negative covenant is that neither party will seek such relief in another forum. And then you can, if you look back at the first sentence, there's footnote number 1, and over the page, that's a reference to the AES case.
And where does not taking anti-arbitration measures fall within that scheme?
Well, it is.
Is that something which is part of the negative obligation in the arbitration agreement, or is that something which is part of the reference contract?
it's part, well, if it's part of the arbitration agreement.
So the 3.139 second bullet point is expressed rather too narrowly. It's not just that you'll only enforce the claim or seek to enforce the claim by means of the arbitration reference. It is that you won't do things to interfere with that reference.
Well, it's not covering the point. It isn't covering. I mean,
Well, that's
I'm
why
not
I'm asking you
criticising
where in this taxonomy you say that because I think
Yes.
I think you would accept that it ought to be a breach of an arbitration agreement, whether the umbrella agreement or the reference, to take steps abroad to stop the reference taking place. Separate point as to whether you can get a peremptory order in relation to it, but that it would be very surprising if that weren't a breach of an arbitration contract. And I'm just asking you where in the taxonomy that comes on your submission.
The two obligations that are being discussed in 1.39 are both obligations in the arbitration agreement.
Yes.
Yeah, and I
they
would
don't
say it comes
include-
within the arbitration agreement.
Sorry.
Comes within the arbitration agreement, the continuous arbitration agreement, if there is such an obligation.
Why doesn't the agreement to refer a particular dispute to arbitration not have a corresponding negative obligation not to take steps to thwart them? In exact parallel to the positive and negative aspects of the agreement to arbitrate.
I think that's the point that I know Justice Popplewell is
Yes, I'm
putting
asking
to.
you.
He's saying there must be such an obligation, but in terms of what is it derived from? Is it derived from the reference or is it derived from the arbitration agreement? And I'm suggesting it's derived from. I'm not taking issue with his point, but I'm saying.
But you're suggesting it's derived from the arbitration agreement.
Exactly.
Although it doesn't fall within the way that the negative covenant is here formulated.
No. But nor does it fall within 3.141.
In a sense,
No, because three
Sorry,
point.
I may have missed. I'm sorry if I missed your point. By the way.
but in a sense, the obligation to refer a particular dispute to arbitration is contained both in the original arbitration and in the specific particular reference, isn't it?
Well, that's not the way it's analysed. I mean, I can see that might be said, but I mean, we're coming to the Supreme Court in a moment because I'm just about to show you why this book refers to AES, because the passages on this are directly supported by AES. So perhaps we could look at that, and maybe if we need to come back to the question afterwards.
Can I ask you another question? Does the agreement to arbitrate, the overarching arbitration agreement, include an agreement to arbitrate in accordance with the chosen rules identified in the arbitration clause?
Yes.
And does it therefore include an agreement to abide by orders that the tribunal has made, which it is empowered to make under those rules?
I can see that. I can see the argument. Yes. I'm not sure that's an express. It's an express obligation, but it may well be an
Well,
implied.
if you agree to arbitrate under ICC rules, then the point I'm putting you to is you agree to arbitrate in accordance with any powers that the tribunal can legitimately exercise in accordance with those rules, and that's part of your original agreement. And that applies to all disputes generally. It applies before any dispute arises.
I can see that argument. I was just hesitating because I was wondering whether that, because we've got section 40 as well, which obliges the parties to comply with orders. But that's subject to it's this eternal conundrum where you've got express rules. Do they displace the statutory rule or not?
And that may be quite controversial. That's
that's
I
right.
mean, we've got Mr. Justice Aiken's case, and
exactly. That's why I was hesitating, my lord, to answer your question, because I was just trying to analyse whether it was answered by reference to an obligation within the agreement and the rules, or an obligation under the Act. But one way or another, there is probably such an obligation.
Right.
but it doesn't answer the point which is my point on the appeal. Not, yeah. Now let's go to the AES case, which is in the Authorities Volume 2 at tab 13. Right, it's the first tab in Volume 2 of the Joint Bundle of Authorities. And if we go first of all to page 354, just above the judgment, you'll see the point that I was making, that this was the judgment of the full court on the 12th of June 2013. And it starts with the statement in paragraph 1: an agreement to arbitrate disputes has positive and negative aspects. Party seeking relief within the scope of the arbitration agreement undertakes to do so in arbitration in whatever forum is prescribed. The brackets often silent concomitant is that neither party will seek such relief in any other forum. So that's the origin of the terminology. And then if we go to 358, Lord Mance's draft on behalf of the court, at paragraph 21, you see the heading just above paragraph 21 on page 358, the negative aspect of an arbitration agreement. And really all of this is relevant, but it discusses the negative aspect of the arbitration agreement, the continuous arbitration agreement, in paragraphs 21, 22, 23. So I'll come back to that in a moment when I come to another proposition.
But that's all dealing with the point that the negative obligation is freestanding from the positive obligation.
Yes, I mean it contains that obligation, the negative obligation.
But you don't have to. The point that was being argued and rejected here is that you don't have to intend to or actually conduct an arbitration in order to take advantage of the negative obligation.
Exactly.
Yeah.
But well, that was part of what was covered. I mean, that was certainly what had given rise to the dispute, that there was no arbitration on foot.
Yeah, but
the reasoning is wider than that. And when we come to paragraphs 46 to 48, you'll see that it's wider than that.
I followed that. We were just skimming rather quickly over 21, 22, 23 and so on. And what I was suggesting is those passages are concerned, are they, with just that aspect, divorcing the positive from the negative, or is there anything else we should be getting out of those?
Well, I mean, I think it is probably more general. I mean, if for example, you look at 23, he says both prior to the Arbitration Act 1996 and indeed subsequently until the present case, negative aspect was well recognised and well established that the English courts would give effect to it when necessary by injuncting foreign proceedings brought in breach of either an arbitration agreement or an exclusive choice of court clause, treated as the counterpart of the statutory power to grant a stay of domestic proceedings to give effect to an arbitration agreement. That's section 9 of the Arbitration Act. A stay is not made conditional on arbitration being on foot, proposed or brought. So, and my lord, you may say this is straying into the facts, but it is the fact, as is accepted in the respondent's skeleton argument at Core Bundle tab 10, paragraph 28, that in the present case, this is paragraph 28, which is on page 122, CB/10/122. That the orders made by the tribunal were based on breaches of the arbitration agreement that form part of the of the contracts. So the tribunal was acting on the basis that there was a breach of the continuous arbitration agreement, just as had been previously analysed by the Supreme Court, was the basis for granting injunction, or giving the orders rather that they made. Third proposition, the distinction between arbitration agreements and references in the Act. We have the Act in volume 3 of the authorities at tab 28. Very quickly, one can see that starting on page 795, section 5 is concerned with arbitration agreements being in writing and what that is concerned with. Then above section 6, we have the heading, the arbitration agreement, and it describes what is meant by an arbitration agreement: an agreement to submit present or future disputes. Section 7 deals with the separability of that arbitration agreement. Section 8 deals with a specific point about death of a party, and then section 9, which was referred to in the passage we were just looking at, which is the stay of court proceedings in breach of an arbitration agreement. So those sections are all concerned with arbitration agreements and the enforcement of arbitration agreements. If we then go to page 798 in the bundle, you'll see above section 15, there's a section that deals with the arbitral tribunal. We haven't put in all of the sections in between, but if you go on to the next page, 799, above section 33, which was what I referred to earlier as the beginning of the provisions relating to the arbitral proceedings. So the heading there above section 33 is the arbitral proceedings, and that section runs all the way through to the end of section 41, which is on page 802, and then
Can we just pause at 33?
Yeah.
Because we there see what we're also going to get at 34 in subpara 2, the use of the expression matters of procedure and evidence. So 33.1 sets out the duty, act fairly, impartially, etc., and subpara 2 is the obligation for the tribunal to comply with the duty in conducting the arbitral proceedings in its decision on matters of procedure and evidence, and in the exercise of all other powers conferred on it. So there seem to be three separate concepts. One is conducting the arbitral proceedings, another is decision on matters of procedure and evidence, and the third is exercise of all other powers conferred on it, which suggests that within the rubric of this section, all of which is governed by the duty of the tribunal under section 33, that it's concerned not just with conduct of the arbitral proceedings, not just with decision on matters of procedure and evidence, but in the exercise of all the powers which are conferred on the tribunal. Is that right?
Well, that's and where are you? Yes, you're talking.
I'm in subparagraph 2. I'm in subparagraph 2,
yes,
which
yes.
identifies when the tribunal is obliged to comply with its section 33.1 duty.
Yes.
And it's conducting the arbitral proceedings, decisions on matters of procedure and evidence, and the exercise of all other powers conferred on it.
Yes.
Which suggests that this section, at least, is not confined to the conduct of arbitral proceedings.
Section 33.
Yeah.
Well, it's the tribunal's duty. Well, you're using, I think you may be using the word conduct of the proceedings in a slightly different way here. And does this phrase exist in section 33?
Yes, 33(2). The tribunal shall comply with that general duty
In conducting, I
in
see.
conducting the arbitral proceedings, in its decisions on matter of procedure and evidence, and in the exercise of all other powers conferred on it. That was the wording I was focusing on.
No, I see that. So it's just drawing a distinction between the conduct of the arbitral. Well, it may be, I mean, it doesn't. It's not necessary to conclude that there's a separate things that don't overlap. I mean, you could be exercising a power, but it could be conducting the arbitral proceeding.
Of course, but
They're
it does
not-
suggest that
they're not necessarily
it's not limited to the powers that
I could-
are exercised in the conduct of arbitral proceedings, and it doesn't seem to sit terribly happily with your suggestion that all these sections from 33 through to 42 are only concerned with conduct of the reference.
No, I didn't make that. I didn't. I mean, I may have been misunderstood if I said that. I said they're all concerned with the reference. The sections 40 to 42 are only concerned with the conduct of the reference. I may have inadvertently given you the wrong impression. These sections are all concerned with the arbitral proceedings. Sections 40 to, if we go to 40 at 801, it says the parties shall do all things necessary for the proper and expeditious conduct of the arbitral proceedings.
Yeah.
So that is related to the conduct. And then section 41(1), powers of the tribunal in the case of a party's failure to do something necessary for the proper and expeditious conduct of the arbitration. So those specifically are concerned with the conduct.
I understand that.
I'm not. So I didn't. I'm sorry if I was taken as suggesting that the tribunal's duty was limited to the conduct in its duty of fairness and so forth in section 33. And that is obviously extends to all of its powers in the arbitration,
Including the grant of anti-suit relief if
Well,
it has that power.
Yes, I mean it extends to the merits as well. Maybe it's all its powers, so it's its powers to make decisions on the merits. But sections 40 and 41, in contrast, are not directed to everything. They are related to the proper and expeditious conduct of the arbitral proceedings or of the arbitration. And then there's a different heading above. So that heading carries through until you get to section 42, which is
Sorry to slow you up, but can I just focus on one or two other parts of that section? So section 34
yes,
is addressing itself to procedural and evidential
yes,
matters and gives particular examples. Section 35 is dealing with consolidation. Section 36 dealing with representation. 37 experts, legal advisors, and so on. These are all specific powers conferred by the Act. But 38, the parties are free to agree on the powers exercisable by the arbitral tribunal. And then we get the same wording as we get in section 44, which is why I asked you whether it was wider, for the purposes of and in relation to the proceedings. So section 38 does it, expressly recognises that the parties are free to confer within that very wide rubric powers on the arbitral tribunal.
yes. Yes.
And that would include the Article 28 power to grant anti-suit relief.
If that is what Article 28 does, yes, which I'm not disputing, although I'm reserving my position. But I may or may not be entitled to reserve my position, but I'm saying I'm reserving my position.
All right.
Yes, and then section 39 is a rather, well, I think it's well accepted that the side heading for section 39 is inappropriate. I believe that it's been said in a talk or an article by Mr Landau, who was assisting Lord Savile with the drafting, that was a slip to refer to provisional awards there. So one should really ignore that and just look at the wording. And then we have sections 40 and 41. And then a new heading comes in, powers of the court in relation to arbitral proceedings. Just in terms of the structure, that heading then applies to section 43, section 44, and section 45, and then we proceed on after that with the award starting at section 46. So just dwelling in a little bit more detail, and we're on to proposition number 4 now. Section 40, parties shall do all things necessary for the proper and expeditious conduct of the arbitral proceedings. So this is a duty which is specific to an arbitration which is on foot. It is not related to the continuous arbitration agreement which gave rise to the arbitration. And it, as I've stressed already, it refers to things necessary for the proper and expeditious conduct of the actual arbitration. And making it clearer still is the use of the definitive article there, the arbitral proceedings. And so there's nothing in section 40 to indicate that that is in any way concerned with the continuous arbitration agreement. Similarly, in section 41, starts by saying, in more or less identical words, to deal with powers in case of a failure of the party to do something necessary for the proper and expeditious conduct of the arbitration. It's not directed to enforcement of the continuous arbitration agreement. And then the looser wording, which we find in section...
You're going to come back, are you, to the argument adopted by the judge and against you that 42A treats any failure to comply with any order as something which engages something which is necessary for the proper expeditious conduct.
I am going to come back to that. Yeah, and because he derived that from Mr. Justice Burton's judgment, section of paragraph 24, Roman 4 in the Pearl case. And I was going to come back to that.
He did refer to that, but it doesn't necessarily depend upon that judgment. It's a point on the wording of 42A.
It is a
anyway, you're going to come back to that.
He cited Pearl as in support of that point, and I was going to come back to it, and I deal with it when I deal with the Pearl case.
Yep.
And then the relevant qualifying wording in section 44, which we've already discussed, is in section 44.1, page 803, for the purposes of and in relation to legal proceedings. So I think that should say arbitral proceedings.
It does say arbitral.
Now, that will take us then to how that was considered by the Supreme Court. It's the fifth proposition. So we go back to the AES case, tab 13 in volume 2 of the authorities. And just pausing, if we may, at page 365, paragraph 44, he says at the beginning of section, paragraph 44, I should, however, say something further about JSE's submission that section 44.2e embraces the granting of an interim injunction to restrain the pursuit of foreign proceedings during a current or proposed arbitration. So he is dealing here with not only cases where there is no arbitration at all, but he's dealing with a submission that section 44.2e does cover current arbitrations. And he sets section 44 out, and then at paragraph 46 points out that the section is the successor to the first schedule of the Arbitration Act 1934 and section 12, subsection 6 of the 1950 Act, and that section 44.2e corresponds with paragraph 8 of the first schedule of the earlier Act and section 12.6h of the 1950 Act. The matters listed in section 44 are all matters which could require the court's intervention during actual or proposed arbitral proceedings. The power to grant an interim injunction is expressed in general terms, but is limited, save in cases of urgency, to circumstances in which either the tribunal permits an application to the court or all the other parties agree to this in writing. There's no power to grant a final injunction even after an award. There is authority, not requiring review on this appeal, that section 44, subsection 3, can include orders urgently required pending a proposed arbitration to preserve or enforce parties' substantive rights. For example, an order to allow inspection of an agent's underwriting records or to sign a proposed transfer to a central bank. And those are the facts of the two cases, Hiscock and Settlement. And he says such orders can be said to be for the purposes of and in relation to arbitral proceedings. But orders restraining the actual or threatened breach of the negative aspect of an arbitration agreement may be required both where no arbitration proceedings are on foot or proposed, and where the case is not one of urgency, and so not within section 44, subsection 3. They enforce the negative right not to be vexed by foreign proceedings. This is a right of a different character, both to the procedural rights with which section 44 is mainly at least concerned, and to the substantive rights to which Hiscock and Settlement cases hold that it extends. One can read in here that he may have had some doubts as to whether Hiscock and Settlement were right in that, because he says earlier that they didn't need to review that. Then he discusses Mr. Justice Cook's decision in the Starlight case. And you can see from the bottom of the page that Mr. Justice Cook treated both section 44 and section 37 as potentially available and made an order under both. And then it's the key paragraph, paragraph 48. The better view, in my opinion, and of course this is a judgment of the whole court, is that the reference in section 44.2e to the granting of an interim injunction was not intended either to exclude the court's general power to act under section 37 in circumstances outside the scope of section 44 of the 1996 Act, or to duplicate part of the general power contained in section 37 of the 1981 Act. Where an injunction is sought to restrain foreign proceedings in breach of an arbitration agreement, whether on an interim or a final basis, and whether at a time when arbitral proceedings are not on foot or proposed, so he's covering both situations, the source of the power to grant such an injunction is to be found not in section 44 of the 1996 Act, but in section 37 of the 1981 Act, such an injunction is not for the purposes of and in relation to arbitral proceedings, but for the purposes of and in relation to the negative promise contained in the arbitration agreement not to bring foreign proceedings, which applies and is enforceable regardless of whether or not arbitral proceedings are on foot or proposed. Justice Coleman in Sakana was correct on this point when he held the court's power to make orders for the purpose of and in relation to a reference in section 12.6 of the Arbitration Act 1950 did not include the granting of relief consisting of either a final or an interim injunction to restrain an alleged breach of a London Chamber of Commerce arbitration agreement consisting in the commencement of proceedings in Florida. So that is the key passage on which I rely. It is not limited to cases where there is no arbitration on foot or proposed. Clearly covers a situation where there is an arbitration on foot. And it's very clear that in either case, the Supreme Court did not regard the grant of an anti-suit injunction to enforce a negative promise contained in the arbitration agreement as falling within the words of section 44. And my submission is that that wording is wider than the wording in sections 40 and 41. So the reasoning applies equally or a fortiori. And that I would say is part of the ratio of the case as well. It is not it's not an obert. I think it's sort of been portrayed by my opponents as an obert dictum by Lord Mance.
What was the argument that was here being addressed?
The argument
Yeah.
that was being addressed was that the court did not have the power under
section 37.
Under
Because-
either provision. Yeah,
Because
because there was no arbitration.
because there was no arbitration.
Yeah.
So
And he says the court does have the power, but it's only under section 37. It's not under section 44.
but the bit that matters is for ratio is the first half of the beginning of the paragraph.
Yes,
That
but
section 44 wasn't intended to exclude the court's general power to act under section 37,
well,
because
but it
that's essentially the argument that was being advanced. If section 44 is intended to cover everything, and section 44 can't apply in circumstances where you don't have any arbitral
well,
proceedings.
that is the headline proposition.
Yeah.
But the reasoning in support of that is what then follows.
Well,
And therefore, what follows is part of the ratio.
well, is it necessary for that?
Because it's the
Is it necessary for that part of the decision? Is what I'm just
Well,
whether or not it's duplicative in a case in which you do have arbitration proceedings was simply not an issue. I'm not saying it's not covered by this, but is the duplicative part ratio?
Well, in my submission, this is all part of the reasoning. It's all part of one paragraph, and if you just stopped after the first sentence, there wouldn't be any reasoning. The reasoning is the second sentence onwards, and it all has to be read together, and it's part of the ratio. That's my submission.
Yep.
And just for completeness, he then, I won't read all of it, but he then goes on to deal with section 9 in paragraph 52, and then section 37 in paragraphs 55 and onwards. So my submission, is this, that there are qualifying words. It's not every order that the tribunal chooses to make, and then makes a peremptory order in respect of under section 41. That is a qualifying peremptory order for enforcement under section 42. It is only one which is necessary for the proper and expeditious conduct of the reference. That does not apply to an order, which the order was in the present case, which was explicitly for the enforcement of the negative covenant in the continuous arbitration agreement, for the reasons explained in that paragraph by the Supreme Court. And therefore, it is wrong to say that any order that the tribunal chooses to make can be the subject of a peremptory order, which the court then has jurisdiction to, or in the sense of a power, to enforce under section 42.
And you say that, as I understand it, because you say section 41(1) identifies the scope of the whole of that section, and the whole of the section is only concerned with matters which are necessary for the proper and expeditious conduct of the arbitration.
I mean, this was
That's
a new regime introduced by the Act. I'm showing you the DAC report in a moment.
Yep.
The new regime of peremptory orders, and then peremptory order that qualifies can be enforced under section 42 by the court. And you have to read the provisions together. You can't, in my respectful submission, just pluck out the words any order and say this means that any order that the tribunal chooses to make is one which is liable to be enforced under section 42.
But section 41(1) is not, at least on its face, concerned with what the tribunal can do. It's what the parties are free to do. Why do you say it's a limitation that's to be read into the whole section?
Well, because it's defining the subject matter of what the parties can make, what they can do, and the subject matter is that they can make provisions in relation to it.
Well, it's not the only section that identifies what the parties can do in terms of conferring powers on the tribunal, which was why I wanted to go back to section 38 and so on, and perhaps more broadly, provided that the agreement doesn't cut across the compulsory parts of Part 1, which are set out in the schedule, the parties can confer any powers on the tribunal.
Yes, well,
and all, I think the argument against you at least one level is all section 41(1) is doing is identifying some of the matters that the parties are in a position to agree, not all of them, and that any order isn't so confined.
But what ultimately we're concerned with is whether there is a jurisdictional limit on the power in section 42. And in my respectful submission, there is a jurisdictional limit, and the limit is it only applies to peremptory orders which are for the purpose of necessary for the proper and expeditious conduct of the reference.
Yes, I mean, your argument depends entirely on what I'd call stage 2 of the 3 stages. When you get to section 42, the reason you say you can't have a peremptory order for anti-suit injunction is because a court order enforcing a peremptory order is because the tribunal don't have power to make it as a peremptory order in the first place.
Well, it isn't a peremptory order which is capable of enforcement under section 42.
But there's nothing in section 42 that tells you that. Your case is the reason you can't enforce under section 42 is that this kind of order is not something which can be made a peremptory order by the tribunal under section 41, as I understand it. An anti-suit order cannot be made the subject
Not
matter.
a peremptory order within
peremptory
the
order.
meaning of the Act
No.
that is capable of enforcement under section 42. Yes.
Wouldn't it be strange if, within the scheme of the Act, if you had peremptory orders made by a tribunal which were then writ in water because the court couldn't support those orders?
Well, yes, but equally it would be strange if the tribunal had the power to enlarge the jurisdiction of the court. I mean, the jurisdiction of the court under section 42 is whatever Parliament intended. It can't be enlarged by a tribunal saying, well, we're choosing to make an order here and in relation to something, and we'll make it a peremptory order. And now that must be enforced by the court under section 42.
But section 42 is a statutory power of the court to enforce anything which can properly be made as a peremptory order by the tribunal. Would you go that far?
What?
I mean, it seems pretty obvious. There's nothing.
It is for the purposes
Well,
necessary for the proper. And
you don't get that out of section 42. You get that out of what a tribunal can or can't do, you say,
Yeah.
in making a peremptory order.
I
You say there are certain types of peremptory order which, even if they're called peremptory orders, the tribunal has no power to make because they're limited in the way you've suggested. If, on the other hand, you get through that hurdle at stage 2 and it's a peremptory order which a tribunal does have power to make, I don't think you're suggesting that then there's any limitation subject to elements of discretion on the jurisdiction under section 42 to enforce it.
The only time it matters whether or not it qualifies for enforcement by the court is when someone asks the court to enforce it. If it's simply an order which is left within the arbitration, as it were, then it doesn't matter whether it's going to be enforced by the court or not. But it can only be enforced by the court if it's necessary for the proper and expeditious conduct of the reference. And the Supreme Court reasoning, it has told us that is not something that falls within the looser phrase in section 44, because it's not something for the conduct of the reference, it's enforcement of the continuous agreement to arbitrate. That's my point. And
if one of the parties contends that the arbitrators didn't have jurisdiction to make a particular order or peremptory order, then that's something they could challenge, isn't it, under section 67?
well, if it was a point of substantive jurisdiction, but actually I think something like this would not be substantive jurisdiction as defined in section 30. It would be a question of the powers, and the powers of the tribunal are dealt with in section 68 2b, I think it is. Or A or B.
Right.
So because there's a distinction in the Act between the powers of the tribunal and the substantive jurisdiction of the tribunal over disputes in general. So I don't think it would be a section 67 point in relation to the power to make or not make this order.
No.
In any event, it could be argued under one provision or another, or on an application under section 42 that the tribunal didn't have jurisdiction to make a particular order.
Yes, it could. Yes, didn't have the power to do it. I mean, it could be argued it didn't have the jurisdiction as well. But that would be unlikely because I mean, there's no general jurisdiction. I mean, if there was a general jurisdictional objection to the reference, then of course. But I'm just hesitating because the definition of substantive jurisdiction, which is used in section 67, is a very particular, limited definition, which is in section 30, subsection 1.
Yes, and confined to awards, I think, isn't it? These procedural matters
It does.
often won't be in
So
an
that's-
award, so you have to wait till later.
Yes, you can only challenge awards under section 67, exactly. Can I take you to the DAC report, which I can take you to it if necessary, but in Lord Justice Clarke's judgment in Settlem and Rouse held that it was admissible if in a case where he held on section. Shall I take you to it? Let's take you to it quickly. This is in volume 1, tab 8. this is an earlier case on section 44 of the Arbitration Act. And if we go to page 126 in the opus bundle, which is paragraph 29, you'll see the point there was construing section 44.3. Set it out into paragraph 29. And he says the question is whether in a case of urgency, Mr. Justice Cook held, Mr. Black submits, the subsection is simply permissive and does not in any way restrict the circumstances in which the court can exercise the powers conferred on it by subsections 44.1 and 2. Or as Mr. Dunning submits, the subsection restricts the powers of the court to make such orders as it thinks fit for the purpose of preserving evidence or assets. And we don't need to be involved with the substance of the dispute, but if you go over the page, paragraph 40, page 128, having considered the arguments on either side, he says, to my mind, section 44 is capable of either construction, and in those circumstances, it's both legitimate and appropriate to construe it consistently with the view of the DAC expressed in the DAC. So there's a number of cases where that has happened. Now, in the present case, we have the DAC report in volume 3. Of the
Just before you go there, section 44 enables a court to grant a moreover injunction in support of arbitral proceedings, and they are not concerned with the conduct and the reference in the way you've been using that expression. They're simply to preserve assets for the purposes of enforcement. So must they not come within the wider wording in section 44?
Well, they clearly do, because they're routinely granted, and that was one of the purposes for which the DAC report enacted E, letter E of section 44.2. Yeah, but that's not the point we're dealing with, which is we're dealing with where the Supreme Court has held that those words do not cover the enforcement of the negative covenant in an arbitration agreement, and therefore it is not possible, according to the Supreme Court, for there to be any application for an anti-suit injunction under section 44. That's the case we're concerned with.
But I'm just wondering why that should be so. I mean, of course, I understand the reliance you place on AES, and we'll have to consider the extent to which it reads across to our case. But if it was really saying that anti-suit relief can't be in relation to the proceedings, it must also admit that in relation to proceedings is wide enough to cover matters which are concerned with the enforceability of the award.
Well,
and
yeah.
what
Yeah, I mean, it's
and
derived.
one question which may arise for us is whether taking anti-suit proceedings interferes with the enforceability of an award. It seems to me pretty obvious that anti-arbitration proceedings do, but simply parallel proceedings may very well interfere with the enforceability of the award. And at the moment I struggle to see why that shouldn't come within the wide wording in section 44 at least, which also permits waivers.
Well, I mean, I simply rely on the reasoning of the court. I mean, that's what they said. It doesn't fall within that. I mean, anti-suit injunctions are not to be sought under section 44. They're to be sought under section 37. Can I just, in terms of a freezing injunction, obviously the reason why it relates to the reference is that there is a claim for the sums, the monetary sums in the arbitration. That's the presumption, is that there is a claim for the monetary sums in the arbitration.
Yeah.
The oddity in our case is that there is no claim for these anti-suit injunctions. I mean, they're not seeking an award in relation to the, they're not seeking anti-suit injunction by way of an award.
No, but they're seeking an award which they want to be enforceable. And if there's an anti-arbitration suit abroad, that interferes with that.
You have my submissions as why they can't, my lord.
Yeah.
And I just want to show you the DAC report before I turn to some of the other authorities, or non-authorities, I would term them. If we go, please, to tab 32. We have here the DAC report in relation to what the then clauses 40, 41 and 42. And one can read through paragraphs 204 to 211, but none of those say anything about the wording that we're concerned with. I mean, they don't comment specifically on.
It was in the bill, was it? Was 41.1 and 41.2 in the bill? Because para 206 seems to leap straight to 41.3, striking out for want of prosecution.
Well, I believe it was. I have to check that actually. I'm assuming that wasn't added at the last minute.
Well, I'd be grateful if that could
yes,
be if that could be confirmed.
I mean, what? Yes, but one way or another, there is nothing in section 4 in the comments on clauses 40 and 41 which comment on the meaning or the effect of the phrase necessary for the proper and expeditious conduct of the reference or the arbitration. But we do have clause 42, and it says enforcement of peremptory orders of the tribunal. Although in clause 41 we have provided the tribunal with powers in relation to peremptory orders, it seemed to us that the court should have power to order compliance with such orders, though unless both parties have agreed, these can only be invoked with the permission of the tribunal. In our view, there may well be circumstances where, in the interests of justice, the fact that the court has sanctions, which in the nature of things cannot be given to arbitrators, for example, committal to prison for contempt, will assist the proper functioning of the arbitral process. That's the relevant phrase that they've used there. The proper functioning of the arbitral process. Now, there is no explicit suggestion that this is to be used for the purpose of enforcing the arbitration agreement or for protecting the enforceability of the arbitration award. It simply says the proper functioning of the arbitral process.
And your case, I think, is that doesn't extend, proper functioning of the arbitral process doesn't extend to complying with tribunal orders which the tribunal has power to make.
Well, it doesn't extend to enforcing, the court enforcing an order which goes outside the proper functioning of the arbitral process, which...
Well, I agree with that, but then I think it must also be part of your submission that the judge was wrong to say that failing to comply with a court order is itself something which is, in the words of 41.1, necessary for the proper and expeditious conduct of the reference, in the words of the DAC report, the proper functioning of the arbitral process. And if one, you're going to come to that,
Yeah.
but if you're trying to get anything out of these words, it's not immediately obvious that the Departmental Advisory Committee wouldn't have treated complying with orders which the tribunal has power to make as sufficient to be assisting the functioning of the arbitral process.
Well,
I mean, why wouldn't it be? Leave aside the wording of 42A.
Yeah.
Why, as a matter of natural language, is it not part of assisting the proper functioning of the arbitral process to ensure that, or assist in the parties complying with orders that the tribunal has power to make?
shorn of the qualification words, I can see the point, but that we're not construing this shorn of those words, and we are construing it in a situation where the other qualifying words have been construed by the Supreme Court as excluding the enforcement of the negative promise in the arbitration agreement.
Yeah, well,
And so, I mean,
I
can see
understand
that
that submission, but
if we were
what that
starting
rather
again,
illustrates is that you don't get any support from this.
well,
If anything, this would suggest a wider interpretation, but you say that isn't what the statute says, and that isn't how it's been interpreted in AES.
I can see it depends on how you approach the matter, whether you think it supports your view or not. But I thought it was right you should see it.
Yes.
In my submission, it does support that it's concerned with the functioning of the arbitral process and not enforcement of the negative covenant in the continuous agreement to arbitration, which is, as I say, a fundamental conceptual and terminological distinction running through the whole of arbitration law and through the Arbitration Act, as the Supreme Court correctly recognised. Now, what about other authorities and legal materials? I can deal with this, I think, fairly quickly. The respondents have obviously done very extensive searches of the relevant legal materials, and the position we've reached is that it is nearly 28 years since the Arbitration Act came into force on the 31st of January 1997. And as far as the parties are able to ascertain, this is the very first case in which it's been suggested that the court can grant an anti-suit injunction under Section 42 of the Arbitration Act. That is despite, as one knows very well, the inventiveness of the advocates at the commercial bar in London. None of the cases cited by the respondents are examples of anti-suit injunctions granted under Section 42. The decision in the Pearl case is not an anti-suit injunction case. So the submissions I've been making based on the decision of the Supreme Court in AES would not have been applicable in that case, and I'll come back to what Mr. Johnson said in a moment. Only one textbook has expressly suggested that an anti-suit injunction can be granted under Section 42, and that is the 7th edition, but not earlier editions, of Mr. G's book. Now we have that in Authorities, Volume 3 at tab 36. And let me just take you to the relevant passage. It starts at page 831 in the bundle, the heading Powers of an Arbitral Tribunal. And this whole section, as you can see from the top of the next page, is headed anti-suit injunctions. That's on the top of page 832. It talks first of all about an award, And then on page 833, it says at paragraph 14089, under section 40 subsection 2, there's a statutory duty to comply with any orders or directions of the tribunal which the tribunal has power to make. A peremptory order can be made and enforced by the court under sections 41.5 and 42.1 of the Act, including by injunction, and that refers then to the Pearl case. And then 2 paragraphs further on, it says the tribunal can also give permission for an application to be made to the court under section 44 for an interim injunction. So it's clear from this that Mr. G is in error, at least in that regard, because that paragraph concerning section 44 entirely overlooks the decision of the Supreme Court in the AES case. So it seems that even Mr. G's book gets things wrong sometimes. And in my respectful submission, what he says in relation to section 40, 2, in the paragraph, the first paragraph that is sidelined on that page, is infected by the same error if my submissions are correct. Now, the judge relied on this textbook.
I think he relied on the passage on page 830 under 661, which is more explicit. The sideline passage there.
Yes, although that's not directed to, that's just general injunctions, not anti-suit injunctions. That's why I went
I'm not sure. Is it? It's section 42 would include power for the court to enforce a peremptory order made by the tribunal where there's been a failure by a party to comply with an interim anti-suit
order. Oh yes, I see that. Yes,
made by the tribunal.
Well, that's the same.
Provided that it's been made by the tribunal acting within its jurisdiction.
Well, it's the same point.
Yeah.
I mean, he cites in support of that the Pearl case, which is not an anti-suit injunction case. So this is Mr. G's reasoning that because in Pearl, which
I'm not sure that's quite fair. Footnote 251
Pearl.
is Pearl, but that's footnoted to including a peremptory order for payment of money on an interim basis.
Oh, okay. Well, then, okay, but then there's no case cited in support of the proposition that an injunction could be ordered for an anti-suit injunction. It's all based on Pearl, and as I say, when you go to page 833,
Well, as I say, I think to be fair to Mr. G, however hard that may be, he isn't expressing his view as one which is established by Pearl. He's just expressing his view.
Well, he's expressing.
You say he's wrong, and later it shows he hasn't taken into account AES, but that's as far as this textbook goes.
But on page where he's actually dealing with anti-suit injunctions, in the first sideline passage, he is saying that is supported by Pearl at footnote 528.
Yes, I see.
And then 2 paragraphs further on, he says the tribunal could also give permission for an application to be made to the court under section 44, but that's wrong. And my point is simply this, that where he expresses the view that an anti-suit injunction could be made for the same reason that in Pearl a money order application was made, he is not taking account of the reasoning of the Supreme Court in AES. And so if my submissions in relation to that are right, then what he said is wrong. And the judge said that he'd not been referred to any authority or textbook which suggests that the passage in question was wrong. In my submission, it is wrong because it overlooks what was said by the Supreme Court in AES. And it explicitly overlooks what the Supreme Court said in AES in the second sideline passage, where it says the tribunal could give permission for an application to be made to the court under section 44. So that's the only legal material which suggests that an anti-suit injunction can be granted under Section 42. My Lord, I'm not sure I need to go through all the other materials that have been put in for the negative proposition that they do not say that an anti-suit injunction can be granted. But for example, we have must avoid companion volume, which is in volume 3, tab 33, page 820. It doesn't deal with anti-suit injunctions. It doesn't even have any discussion of the words necessary for the proper and expeditious conduct. Then we have Harris and Plantrose commentary in volume 3, tab 34, 822. Again, this doesn't say anything about anti-suit injunctions. We have Russell, which is Authorities, volume 3, tab 35. Again, it doesn't say anything about anti-suit injunctions being granted under Section 42 and has only a very brief reference to the qualifying words necessary for the proper and expeditious conduct of the arbitral proceedings. Merkin and Flannery, 6th edition, is Authorities, volume 3, tab 38, page 838. And we have 839, we have cited that in our skeleton argument, because they do suggest that there must be a limit on the phrase any order, but they don't develop the point. The Handbook of ICC Arbitration, which my learned friends have referred to, which is Authorities, volume 3, at tab 39, page 842 and at 843. There's no reference to Section 42 there at all. And the new Mustel and Boyd, which does have an extensive discussion of sections of 41, it doesn't have any reference, and this is in volume 3 at tab 40, starting on page 858. It's quite an extensive discussion of Section 41 over several pages, or at least two pages. Injunctions are considered on page 860 and following. But there's no suggestion anywhere that there could be an anti-suit injunction sought under Section 42. The Pinson-Mason's submission to the Law Commission, which is referred to in my learned French skeleton argument at CB tab 10-131 and footnote 4 on the same page, and there's no reference in that citation to the tribunal granting anti-suit injunctions. And then there is an interesting point made in relation to the explanatory notes for the new emergency arbitrator amendments to the Arbitration Act. And what has happened is that there's been a new Section 41A added, and some consequential amendments to Section 42 to make it clear that a peremptory order, which is capable of enforcement under Section 42, can be made by an emergency arbitrator if one has been appointed under the relevant rules that are applicable to the arbitration. There is nothing, so we have the explanatory notes, which are in volume 3, tab 41, at page 872. But they don't say anything about anti-suit injunctions, so it doesn't help one way or another in relation to that.
Well, I think the point on Section 41A is put against you a bit more widely. It has the same rubric about the ability in 41.5, ability to make an order, make a peremptory order for failure to comply with any order. But it nowhere in Section 41A does it have any of the language of necessary for the proper and efficient conduct of proceedings. So if one's dealing with an emergency arbitrator, which there's power to appoint under several rules like the ICC and LCIA rules, where would you get the limitation?
No, we don't. You don't, and that's it's actually a point in my favour, my lord, because I was quite curious to read that my lord thinks it supports his case, because There is no limitation there is no equivalent limitation
For
in
emergency
relation to,
arbitrators.
emergency arbitrators. And there's a very good reason for that. Because emergency arbitrators, you have to think, why are emergency arbitrators appointed? They're not conducting the reference at all. That's not their job. In fact, they're only in place while there is no tribunal in place to conduct the reference. And they are there to grant emergency relief in lieu of having to go to the court under Section 44. And you may be aware, for example, in Gerald Metals, Mr. Justice Leggett held that where you could go to an emergency arbitrator under the relevant rules, you cannot any longer apply to the court under Section 44. So the purpose of emergency arbitrators is much, much wider than making orders for the proper conduct of the what was the wording? The necessary for the proper and expeditious conduct of the reference. They are explicitly there to grant interim substantive relief, for example, which is so in lieu of going to the court under Section 44. So they may well be doing something which is nothing to do with the conduct of the reference. I mean, normally an emergency arbitrator, for example, will be asked to grant some urgent injunctive relief. That's the classic case. That may be of the type, for example, in Settle M, where the court was asked to prevent one party from frustrating the contract by ordering it to make an application to the Central Bank of Russia for permission for the transaction to proceed, so that the time limit didn't expire before the contract could be addressed by the tribunal.
But is it your case?
So
that
there's
if
a deliberate omission of any qualifying words
I
in
understand.
relation to
I understand what you're saying in relation to that. But is it your case that if an emergency arbitrator makes an anti-suit order and makes it as a peremptory order, then the court does have power under Section 42, and if not, why not?
Well, because there are no limiting words in relation to the emergency arbitrators.
So there's nothing in the nature of the relief itself, i.e. that it's an anti-suit injunction, which is objectionable. That would still run up against the distinction you've been drawing between the arbitration agreement as a whole and the reference contract. But you say for the tribunal, once it's constituted, they can't produce a peremptory order which can be enforced in that way, but before the tribunal is properly operated, the emergency arbitrator can.
Well, there is.
I mean, is that a fair characterization of the logic of your argument?
What I have said, that there are no qualifying words which are directly applicable to the emergency arbitrator, and that is probably intentional, because why else would you not replicate the words that are in sections 40 and 41 in relation to an emergency arbitrator?
Well, they may not be qualifying words. They may not be qualifying words, but I think the point that matters for you to deal with is what on earth is the logic of statutory construction which enables the court to give its teeth to a peremptory order for an anti-suit injunction by an emergency arbitrator, but doesn't enable it to give its teeth to a peremptory order when it's made a week later, when the tribunal is actually constituted.
Well, okay. I mean, that's a. I mean, the logic is that there's a difference in the powers and there's a difference in the legislation.
But there isn't a difference in the powers of the arbitrator. The emergency arbitrator has the powers to grant interim and conservatory measures. So too does the tribunal once constituted.
But only for the purpose of, or in my respectful submission, the whole scheme is orders that are necessary for the proper.
I know, but that assumes what you're setting out to prove, and I'm just trying to tease out whether you can identify a rational reason for a difference between the position of an emergency arbitrator position of a tribunal, both of which are at an
Well, I'll repeat it.
early
I have
interlocutory
identified
stage.
a reason, which is that where you have an emergency arbitrator,
Yeah.
according to the general vessels, Mr. Justice Leggett, you cannot any longer apply to the court for relief. All the types of relief that are listed in section 44, if they can be granted by the emergency arbitrator, you have to go to the emergency arbitrator, and you can't go to the court. So the emergency arbitrators are in a much more expanded role, because it's in locus of the court. It's not.
But you
it's
can't
not
go
in
to
locus of
you,
the
you
tribunal.
can't go to the court under section 44 if you've got a constituted tribunal. If you haven't gone to the tribunal first, can you?
Yeah, but this is
But
this
why-
is,
so why
this
is
is
that-
before you've got a tribunal.
Well, I know it is, but why is it a point of distinction that under section 44, in the case of an emergency arbitrator, you've got to go to the emergency arbitrator first, when that is the case, equally the case when you have a fully constituted tribunal?
Well, the problem is we're talking about all different types of arbitration here, and whether it's the default position or whether there are LCIA or ICC rules in place. Where you don't have an emergency arbitrator unless you have a set of rules which provide for
Yes,
an emergency.
quite. You don't get it in every case, but
And those rules will themselves describe what the emergency arbitrator can do.
Yeah.
And so that any
and assume it
limits-
includes granting an anti-suit injunction.
well, it may or may not explicitly include an anti-suit injunction, but the powers will be whatever are the powers in the rule that gives locus to an emergency arbitrator. There is no default emergency arbitrator, as there is in relation to the tribunal, which is the Act applies to all tribunals, but the emergency arbitration provision doesn't apply unless there is an emergency arbitration provision in the rules. So it's a hybrid. It's not exactly the same as the ordinary tribunal at all. Yeah. And the other thing to bear in mind, of course, in all of this is that there's no gap in the sense that
I mean, the ICC rules at Article 29 provide for an emergency arbitrator to grant urgent, interim or conservatory measures. So it just mirrors Article 28.
and it doesn't tell you
So
what that
it's-
is exactly.
No, but if Article 28 includes anti-suit injunctions, which it does, so too does Article 29.
Yeah.
So we go back to the position, there's no relevant distinction between the powers of the emergency arbitrator if they're needed urgently and the power of the tribunal once constituted.
Well, there is the distinction that the tribunal obviously can grant final anti-suit injunction relief because it can make an award.
Yeah.
And we, as part of our submissions, that there is no gap if my construction of section 42 is correct, because an application can be potentially made to the court under section 37, or it can be there could be an application for an award of anti-suit.
But only a final award, not a
It would
You'd
be
have- you'd have to wait
it
for a
could be
final award.
partial final award. It doesn't have to be a final award. It can be an expedited partial final award, or you can go to the court under section 37. So, so the two, just to give you an example of the sort of things that the emergency arbitrator might do, those two cases that we saw referred to in section by Lord Mance, in the paragraphs that we were looking at, of urgent delivery of documents or an urgent order to the central bank for permission, those types of relief can be granted by an emergency arbitrator. And indeed, if you've got an agreement for an emergency arbitrator, they will not be relief that you can seek from the court if Gerald Metals is correct. So it makes sense that there is a restriction imposed on ordinary tribunals, but not one imposed on emergency arbitrators. But there is also a question of whether or not one can in fact construe an act which came into force on the 31st of January 1997 and has been in force for nearly 28 years by reference to a legislative change that took place in August this year, took effect in August this year. In my respectful submission, one can't. Whatever sections 40, 41 and 42 meant when they were enacted is still what they mean. You can't re-engineer, reverse engineer their meaning by reference to a legislative change that was made in the 2025 Arbitration Act. If the provisions relating to ordinary tribunals have not themselves been changed.
I understand the submission. I suspect there will be some authority on whether you can interpret a statute by reference to a subsequent statute. I think there's some authority that you can't or you rarely can by virtue of subsequent delegated legislation. But
here we've got a situation where the provisions relating to what I might call ordinary have not themselves been changed, but there have been added a different provision in relation to an emergency arbitrator, which only applies where the parties have provided for that in the rules that they've incorporated into their arbitration agreement. And in my respectful submission, whatever the Act meant before legislative change took place, there's no reason to think that Parliament intended to change the meaning of those provisions by the addition of section 41A and the small consequential changes that it made to section 42, which simply add reference to a peremptory order made by an emergency arbitrator. They didn't touch the qualifying phrases in sections 40 and 41. So what can we conclude from this? That we are in genuinely new territory in terms of the decision of the court. After some almost 28 years, the court is being asked for the first time to make an anti-suit injunction under section 42. I've just very briefly mentioned the Supreme Court decision in the Hashwani case. That was a case, by the way, about the independence and impartiality of the arbitrator, Jivraj and Hashwani. It's Authorities, Volume 1, Tab 11. It's been relied upon by my learned friend. But if you look at the paragraph that's cited by them, which is paragraph 42, you'll see that Lord Clark was simply making general comments about the independence of the arbitrator from the parties, and he was not considering anti-suit injunctions at all. And that then brings me to the Pearl case, which the judge referred to and relied upon. And the first thing to note about the Pearl case is it's not an anti-suit injunction case. So the submissions I've been making about the effect of the qualifying phrases in sections 40 and 41, based on the reasoning of the Supreme Court in the AES decision, would simply not have been in point if I had made those submissions in that case, because it was not an anti-suit injunction case. It was a case where an order had been made by the tribunal for $100 million, if I recall correctly, to be paid by one party to the other. Now, we have this in tab 14 of the volume 2 of the Authorities bundle. And the relevant passage starts on page 382 in the Office Bundle numbering. And it's in the left-hand column, paragraph 17. And you see the submissions that Mr Pollock made on one hand and I made on the other in paragraph 17. And it then set out part of my argument there. And at paragraph 21, he said, accordingly, in the consequential subclauses of section 41, which by virtue of section 41.2 apply unless otherwise agreed by the parties, powers are given to the tribunal. Consequently, although Mr Dunning, QC, did not expressly so submit, it must inevitably be that the words in section 41.5, which I've cited in paragraph 19 above, must be construed as dealing with where a party fails to comply with any such order or directions of the tribunal, i.e. an order to do something necessary for the proper and expeditious conduct of the arbitration. And then I referred to Hansard, and the argument goes on. There was reference to Mr Justice Dyson's decision in Makub, which was also about an order for the payment of money. And then paragraph 24, he says, it seems to me that Mr Dunning's submissions go too far. And then he sets out what he says Mr Pollock submitted. And then paragraph 25, he says, in the second sentence, although the proper and expeditious conduct of an arbitration would normally include the parties' compliance with any order which the tribunal may make, nevertheless it's clear that although arbitrators will in fact be making orders which they consider necessary for the proper and expeditious conduct of the arbitral proceedings, not every breach of every order will lead to a peremptory order. There's clearly room for de minimis. I do not, however, consider it's a requirement for arbitrators in making every order to spell out either that the order that they're making is so necessary, or once the order is made and a party persists in not complying with it, that it's necessary for the proper and expeditious conduct of the arbitration that the parties should so comply. And then he goes on in the next paragraph. He says, Mr Pollock points out that the detailed submissions that were made to the tribunal prior to the 10th of July ruling by the claimants and responded to by the respondents, some of which he set out. They were reminded of American cyanamide, and Lord Hoffman, who was one of the arbitrators, referred to the balance of justice. And then he says, however, it's entirely clear that they were being asked to make and were considering an interim measures to preserve the arbitration, the subject matter of the claims. I refer in particular to paragraphs 12, 76 and 77, set out in paragraph 6 above, and paragraph 122 of the respondents set out in paragraph 7. The arbitrators did not spell out a reference to the proper and expeditious conduct of the arbitration, but they clearly concluded that it was appropriate that the status quo ante, whereby the respondent paid for what was lifted, should be restored, and that that was necessary for Dana in particular to be able to continue with the arbitration and be in a position to obtain any relief. So what actually happened in this case is that the judge held that it was not necessary for the tribunal to spell out why they considered that compliance with their order was necessary for the proper and expeditious conduct of the reference. But he held, looking at the matter, including the submissions that had been made earlier, that it was necessary for the proper and expeditious conduct of this particular reference that a payment should be ordered because it would restore the status quo ante under which payment was made for oil as and when it was lifted. And so the order would enable the claimant Dana to be financially able to continue with the arbitration and be in a position to seek relief. And that's all in paragraph 26. So that was a decision about a money payment order on the particular facts where the tribunal had ordered the payment of money in order to restore the cash flow to the contractor so that it could continue with the arbitration and seek ultimate relief. Now, Mr Justice Butcher relied upon the paragraph which is 24 Roman 4 in his judgment, paragraph 50, and the respondents relied on it again in this appeal. And in my submission, that reasoning is wrong. And it's wrong because it's entirely circular to say that any order which a tribunal makes must, because they have made it, be necessary for the proper and expeditious conduct of the reference. It's a logical fallacy to say that every order which a tribunal makes must necessarily be for the proper and expeditious conduct of the reference, which is what this circular reasoning amounts to. So, on a fair construction of sections 40 to 42 taken together, we submit that Parliament cannot have intended that every order or direction that a tribunal might make would be enforceable via contempt proceedings.
Why not?
And
Sorry, why not?
because, in my respectful submission, the Parliament has used the phrases necessary for the proper and expeditious conduct of the reference.
Yes.
And it is, in my respectful submission, circular to say, well, the tribunal has made this order, therefore it is necessary for the proper and expeditious conduct of the reference.
Isn't that what Parliament has said in section 42A in identifying within subparagraph 1, namely all things necessary for the proper and expeditious conduct of the arbitral proceedings, including complying without delay with any order or directions of the tribunal?
Yeah, but
Isn't that what it says?
But that depends whether you read that as subject to 40 subsection 1, because subsection 41 describes the subject matter of section 40 as being things that are necessary for the proper and expeditious.
Well, I understand that. The first question we have to address is whether 41.5 is limited to matters that are necessary for the proper and expeditious conduct of the arbitral proceedings. But then stage 2 is, if you're right about that, is the fact that the tribunal has made an order which itself sufficient to give rise to it being something which is proper and necessary for the proper and expeditious conduct of the arbitral proceedings, and that is addressed in section 40. That's got nothing to do with section 41.1 or 41.5. You're through that. You're through that hurdle. Let us assume over that hurdle.
But section 40 subsection 2 is qualified, in my respectful submission, by section 40 subsection 1. In other words, the whole subject matter of section 40 is things that are necessary for the proper and expeditious conduct of the...
Yes. And it defines them as including complying with any order or directions of the tribunal.
That must be read as meaning any order that is covered by this section, namely one which is necessary for the proper and expeditious conduct of the reference. Because otherwise, what it amounts to is because we have made this order, it is for the proper and expeditious conduct of the arbitration, which is in my respectful submission, circular.
But it assumes that, let me assume for the time being, this may be controversial, but assume that it only extends to orders which the tribunal had power to make, which may or may not be a proper qualification, but assume that it is. Why should Parliament not have intended that if the parties have agreed that the tribunal has power to make an order, the very making of that order, and indeed the compliance with the order, is something which is necessary for the proper and expeditious conduct of the arbitral proceedings? Why shouldn't that have been Parliament's logic?
In my respectful submission, we're talking about a situation where the court's powers of enforcement are, including by contempt, which is the key point which you see from the DAC report, in the paragraph we looked at, are lent to the enforcement of an order made by the tribunal. And it cannot be, in my respectful submission, that every single order that tribunal chooses to make is subject to enforcement by contempt.
But-
It simply.
But you go
cannot
further.
have been-
You have to go further, I think. You have to say that there isn't even any duty under section 40 on a respondent against whom an anti-suit order has been made to comply with it.
No, I don't say that.
Well,
I say that.
then is it not an order which falls within section 40, which is concerned with things that are necessary for the proper and expeditious conduct of the arbitral proceedings? If it's not, where is the duty? Where is the duty on a respondent to comply with it?
Well, what I say is that the power to enforce under section 42 is limited to orders and peremptory orders which are made for the proper and expeditious conduct of the reference.
Assume you're right about that.
And that's all I need.
No.
That's the only point I need.
No, it isn't the only point you need, because then it is said there are two further points that you have to address. The first is the point we're on at the moment, that complying with an order lawfully made by the tribunal is made clear in 42A as being something which is itself necessary for the proper and expeditious conduct of the arbitral proceedings. That's an additional point that you have to meet. And then there is a third point you have to meet, as I understand it, which is, even if that's not so, anti-suit relief can be necessary for the proper and expeditious conduct of the arbitral proceedings. Anti-arbitration relief is obviously designed to interfere with that conduct. And I think it said even parallel proceedings are likely to interfere with the conduct of the proceedings. So you've got all three levels, and you've been addressing us so far just on the first ground.
Well, but
Assume you're right about that. Assume you're
assume
right that the only orders
Yes.
that the court can enforce by way of a peremptory order are those which are necessary for the
Right.
proper
Right.
and expeditious conduct of the
Right.
proceedings.
and then so on that assumption,
Yep,
I don't get any. If I don't get beyond that, then none of these other questions.
exactly. But
But on that assumption, it cannot be that on that assumption, the Parliament has set a restriction on the types of orders that can be enforced, namely those which are necessary for the proper and expeditious conduct of the arbitration. And the question is that restriction then reduced to zero because every order that a tribunal makes is by definition one that must be complied with, and therefore, because it must be complied with, it is necessary for the proper and expeditious conduct of the reference? Or does the limitation continue to apply so that one doesn't get the circular reasoning, because we've made this order, it is necessary for the proper and expeditious conduct of the arbitration? And in my respectful submission, the same point applies at this second stage, that one can't nullify the qualification which Parliament has introduced by saying, well, it has no practical effect because every single order is one which, if it has been made, is necessary for the proper and expeditious conduct of the arbitration, even though it is an order which is not related to the conduct of the arbitration. It is an anti-suit injunction, which the Supreme Court has said doesn't even fall within the wider phrase in relation to the purposes of the arbitral reference. So I can see how you can split it into those different levels, but ultimately it all comes back to the same question of what was Parliament's intention? Was it Parliament's intention that there should be enforcement of orders which were not in themselves necessary for the proper and expeditious conduct of the reference? Now, it is common ground here the reference is complete, is continuing completely
But
unaffected.
just before we leave that, I mean, would it not be said that thumbing your nose at the tribunal and saying we don't care that you're making an order against it, we're simply not going to comply with it, it is something which interferes with the proper and expeditious conduct of the arbitral proceedings?
Well,
I mean, one would have thought so.
well, I rely on the reasoning of the Supreme Court in relation to a lesser phrase, a weaker
No, but the
phrase.
Supreme Court wasn't addressing this at all as to whether an order which the tribunal had power to make and had made. But it wasn't addressing that question, was it?
But as I showed you, it's common ground that the tribunal made these orders for the purpose of enforcing the negative covenant in the arbitration agreement. That's common ground, and I showed you a learned friend skeleton argument where he said that. So that's the basis of these orders. It's not.
So you say that the PO numbers, whichever they were, 18, 22 and 23, were not made for failure to comply with the earlier orders? Do you?
The orders were made to enforce the negative covenant in the arbitration agreement.
But not. I think this is a necessary part of it. They weren't made because there had been a failure to comply with an order or direction of the tribunal previously. Because if they were, then they come within the rubric of 42A.
Well,
I haven't looked at the orders. I've only looked at the passage you've shown me in the skeleton, which may not be addressing itself to this particular question. But I would be surprised if. Let me make it clear. I'm not saying you're wrong on your construction of 42A. I understand your submission on that. What I'm cavilling with at the moment is, if you're wrong about that, you can say, oh well, that doesn't matter because actually that wasn't the basis on which the peremptory orders were made.
Well, let's just look at the skeleton in a bit more.
Well, should we look at the peremptory orders? Wouldn't that be more helpful?
Yes, but let's.
If you understand the point I'm on, which is quite a narrow one, and it may be that it wasn't really the submission you were making, but as I understood it, you had a fallback on 42A, which is even if 42A does make any order that the tribunal has made, one which is necessary for the proper and expeditious conduct of the arbitral proceedings, that wasn't the basis on which these peremptory orders were made, and therefore that in itself is a bar to the court enforcing. If you weren't making that point, we can leave it.
Well, I am making 2 points. One is that is why the anti-suits injunctions are granted in to enforce the negative covenant in the arbitration agreement, as explained by the Supreme Court. And that is, and the related point is that is in fact why the orders were made in this particular case, as the tribunal themselves stated.
Right, but let's look. Then we do. I think we do then need to look at the peremptory orders. Speaking for myself.
Yeah. So just to give you that in more detail, at page 122.
Oh, sorry, where are we in?
Core bundle, page 122, tab 10. This is what
This is back to paragraph 28.
So
This is back to the skeleton, is it?
but I just want to give it a bit more context to it because we weren't answering your lordship's question earlier. And he says that in paragraph 28, tribunal came to the unsurprising conclusion that the first and second Russian court actions of the Russian anti-arbitration applications constituted breaches of the arbitration agreements that form part of the contracts, and accordingly made interim peremptory orders that withdraw the second Russian arbitration, immediately take all necessary steps, stay the first Russian action, withdraw the Russian anti-arbitration applications. The tribunal, and then 29, tribunal gave the respondents permission to make a section 42
Well,
application.
you may be right, but I have to say, speaking for myself, that's entirely consistent with it being the case, if it's the case, which is why I'd like to look at the orders,
Okay.
that they made the original orders on that basis, and accordingly, when there was a failure to comply with them, they made the peremptory orders. That's not quite addressing.
Okay, well, let's go to
Let's look at the orders.
Supplemental Bundle 2. Oh, sorry, Supplemental Bundle 1.
Tab 2,
At tab 2, page 129. So it starts at page 78. It's procedural order number 18. And page 129, which is
129, did you say?
yeah, paragraph 126. And then 131. And 136. So those are the I think the paragraphs that my lady friend Skeleton was referring to. My lord, I'm told that I ought to have suggested a transcriber break, but I don't know whether that's normal in this court or not.
It's
I
not.
don't think it is.
It's not.
No. I mean, just as one other point, which is common ground, and I think I'm but the arbitration hearing is arranged for January.
Is there a date in January?
Well, there is a date. I mean, there is
can we-
one small hiccup in that, and there's nothing to do with my clients, but you may know that Mr. Lever is not very well, and he
I
has
didn't know
just
that.
resigned from the tribunal yesterday.
Oh, I didn't know that.
So, but subject to that, everything was planned to go ahead with 2-week hearing in January. So the conduct of the dispute resolution in London is completely unaffected by the Russian proceedings, as things stand. I mean, it may be affected by Mr. Lever's position. I have simply I'm not involved in the arbitration, and neither is my junior. So, but I do know that Mr. Lever resigned, and but until that happened, the hearing is due to go ahead in January, unaffected by anything that's happened in Russia.
But your argument would be the same if the effect of what had happened in Russia was to prevent the arbitration taking place.
Yes, but it would. But as a point of fact, it has not affected the conduct of the, and then it's common ground that if the hearing is going ahead, it's.
Well, that doesn't mean it hasn't affected the conduct.
That depends what you mean by conduct.
Well, I'll see if that is common ground.
I mean, I think the final point I wanted to address is that a point is taken, but paragraph 51 of the judgment under appeal contains a finding of fact. This is at CB, the core bundle, tab 11, page 154.
Yeah.
Paragraph 51. And in my respectful submission, there's nothing in this. First, it doesn't look like a fact finding, and Mr. Justice Butcher didn't have any evidence before him as to what the effect, if any, of the proceedings in Russia would actually have been on the conduct of the arbitration. So it's without any such evidence, it's unlikely that he would have intended to make a factual finding. But in any event, Mr Justice Butcher granted permission to appeal on the very arguments that I have run on this appeal. And so our point is that as a matter of law, anti-suit relief of the type at issue here cannot be granted because it doesn't satisfy sections 40 subsection 1 and section 41 subsection 1 as being necessary for the conduct of the arbitration, as it is for the purpose of enforcing the negative covenant in the arbitration agreement. And the reasoning is that this is not a power which is necessary for assisting the conduct of the arbitration or the functioning of the arbitration, as the DAC called it, and this type of relief is relief that the court cannot give. And even if the court did intend that paragraph 51 to be a finding of fact, it cannot be the case that the court can clothe itself with a power which Parliament didn't intend to bestow upon it by purporting to make a factual finding so as to give itself that power. So in my respectful submission, the points that my learned friend makes in relation to paragraph 51 are taken nowhere. Unless I can assist you further, just been handed a note. I mean, I have made the point more than once, but I'll just make it again, that we're not saying that there is no route available to my learned friend's clients in this situation. There is potentially available to them the section 37 route, and there is the route of seeking a partial finding or seeking to enforce that. But what we do say is that they cannot take the section 42 route because that is not this is not something which relates to the conduct of the arbitration or the functioning of the arbitral process, as the DAC put it, and it runs counter to the reasoning of the Supreme Court in the AS case.
Thank you.
Can I just get some furniture delivered? Thank you. Lord, my learned friend says that the arbitration is continuing. Everything's set fair, subject to the unfortunate position of Mr. Lever. Everything's set fair, the arbitration is continuing, and he said a moment ago that it was completely unaffected by anything that happened in Russia. Could we have on the screen, please, supplementary bundle 3, tab 31, at page 617.
I only have 2 supplemental bundles.
Well, I'm sorry about that. It is.
Tab supplemental bundle tab.
Bundle 3, tab 31, page 617. You should be looking at a letter from.
These were the
new ones.
they've gone into our bundle too.
I'm grateful.
All right.
I can't see it.
Anyone with the cable in the transcriber break, the plan is to come in and switch it.
So I haven't been able to see these screens for the last half hour. I haven't complained about it, but now it's in my submissions. I would like to see these screens, my lord, because I've only got electronic bundles. But can I carry on for the moment, blind as it were? You should be looking at a letter from my instructing solicitors.
Yes.
The critical paragraphs are paragraphs 5 and 6. But it's not a very long letter. Perhaps the court will just read it to yourselves. And then can I give you 2 other references?
Should we just read that to ourselves?
Yes.
Yes. And where are we going next?
The reply is at tab 32, page 619. Paragraph 3 sets out the generous offer from the other side, which the court will digest.
Right.
And finally, page 620 is a response from my instructing solicitor. So, my client's very attendance here, never mind participating in the arbitration, has been the subject of an order obtained by the other side in Russia. Yeah, Mr. Dunning says the arbitration is continuing and it's unaffected. It's clearly been completely discombobulated by the orders obtained in Russia. That's the point. And they've obtained this relief, which seeks to inhibit.
But he would say, but you're here.
But we're here, of course we're here, of course we're here. Yeah.
So his point is, the effect of the Russian orders hasn't in fact been, in practical terms, to inhibit your conduct of the appeal.
Well, it hasn't stopped me being here, but if one puts oneself in the shoes of the arbitrators, considering litigants who are going to the foreign court, making starting proceedings there which duplicate the counterclaim they make in the arbitration, then applying for interim measures and applying for anti-arbitration relief, and they say to themselves, are these steps being taken in Russia going to interfere with the proper conduct of my arbitration? The answer is obviously yes. And the pretense that somehow they don't interfere with the proper conduct of the arbitration is just a truly fantastic submission. So we set out the background. I understand, of course, why Mr. Dunning wants to treat this as a fact-free appeal. I mean, I would too if I was in his case, his shoes. I understand that, and he's treated it essentially as a fact-free exercise, and I'm going to try and do the same because we're dealing here obviously with points of supposed principles of law, and I'll try and keep it factually light if I can. We set out the background fairly fully in the skeleton, and I know the court will have digested that. So I want to pick up the skeleton argument. First of all, at page 35, sorry, paragraph 35, and Mr. Justice Butcher's order. And I'm not going to deal with section 37 in accordance with your lordship's indication at the beginning, but Mr. Justice Butcher granted permission for the amendment to join in, to add section 37 onto the court's menu, as it were. He granted permission to appeal on this single ground, and he made the order, which we've summarised in paragraph 35. And then subsequently, since Mr. Justice Butcher's order, there was then the application for a stay, which was rejected. That was then renewed to the Court of Appeal, and Lord Justice Males also refused the stay. All the while, the appellant has been proceeding in Russia and obtaining the relief, most recently, as we say in paragraph 40, on the 10th of December from the St. Petersburg Tribunal Court. So, the starting point and the finishing point in our submission.
How much, I think the figures you've given in paragraph 5 are partly in euros, partly in US dollars and partly in rubles.
Yes.
How much do they amount to in all, in one currency we can understand, euros or dollars? I'm afraid I'm no good on my ruble exchange rate.
About 860 million euros, I'm told, give or take.
Thank you.
So I want to go to paragraph section 40 of the Act. order AB 33801. My learned friend's argument entirely depends on his reading of the words in section 41A, all things necessary for the proper and expeditious conduct of the arbitral proceedings. The first point to make is that section 40 is talking about what the parties must do, shall do. And if we look at the previous sections, as my Lord Justice Popplewell has observed, there are lots of sections between 33 and 39 which explain what the parties can do, the powers that they can confer on the tribunal. Section 40 is concerned with the duty of the parties to do all things necessary for the proper and expeditious conduct of the proceedings. And not surprisingly, part of the rules of the game, as it were, are that a party has to comply with orders made by the tribunal. That's what they've signed up to. They've signed up to an arbitration agreement. They've signed up to the ICC rules, including Articles 28 and 29. And when the tribunal makes an order, that order has to be complied with. That's the duty that is imposed on the parties by Section 40, subsection 1.
Is that qualified by having to be an order that the tribunal has power to make?
Well, if the tribunal makes an order as it were outside of its jurisdiction, that, in the sense that it's contended that it's not something that was properly before the tribunal or whatever, no. The tribunal's got the power to decide its own jurisdiction and to construe the arbitration agreement and to make orders. And if somebody...
Well, there may be two quite different reasons why the other party might want to challenge the ability, to use a neutral term,
Yes.
of the tribunal to make the order. One might be truly jurisdictional in the sense we're normally using it, such as there is still a dispute as to whether they were party to the arbitration agreement, etc., etc.
Yes.
The other may be a challenge to whether the rules permit, or the parties have agreed to confer on the tribunal the power. In either event, whether what the tribunal purports to have done is within their powers.
Yes.
As to the first, I can understand you saying, well, if the tribunal has competence,
Yes.
that's for the tribunal, and if they've decided they have jurisdiction and they've made a power that they undoubtedly made an order they undoubtedly have power to make,
Yes.
then that's covered. But what about an order where there's a dispute as to whether the rules permit an order of that kind?
Clearly the tribunal...
That's not a competence. That's not within the jurisdiction to decide their own jurisdiction.
No, that's not a jurisdiction in the pure sense of the word question, like a square corner jurisdiction question. Clearly the tribunal, if the matter is before it, will have to form a view as to what the scope of the rules is. They'll then make an order, or they won't make an order. If the order is breached, they may make a peremptory order. They may give permission to come to this court under Section 42. And when we get here, this court, in considering whether to make an order under Section 42, will be able to address itself to that question.
But is it addressing it as a matter of discretion?
Yes, it is.
Or is it saying, when we look at 41.5 and 42A, the word order doesn't mean any order they choose to make, which may be aimed at someone because they've got red hair. It means any order which they have power to make as a matter of construction.
Well, it means any order. I mean, one can think of irrational examples, making an order against somebody for having green hair or red hair or whatever. Clearly the court wouldn't make an order under Section 42 to commit somebody for contempt for breaching such an order as a matter of its discretion. That's how it works. None of this arises here because it's common ground, I think, that it is common ground that the Article 28 of the ICC rules confers power to make anti-suit and related orders. That's what the tribunal did. So Mr Dunning accepts that the tribunal had power to make an anti-suit order at my lord's first stage of the analysis. He accepts that. He accepts that the court has got power under section 42 to enforce peremptory orders. That's my lord's step 3. But something happens at stage 2 on my learned friend's analysis, because somehow there is no power, the tribunal has no power in any circumstances to make a peremptory order to follow up on the procedural order requiring the compliance with the directions of the tribunal. Why on earth should that be? What would the purpose be of the tribunal making an order which it can't then follow up with a peremptory order? It wouldn't make any sense at all. And the point in section 41A, which I'm going to come back to in a bit later, the point about section 41A is that that has been inserted by the 2025 Act into the 1996 Act. It's not a question of using a later act to construe the earlier act, because the sections we are primarily concerned with, as Mr Dunning points out, haven't themselves been amended. But what this court must do is to construe the Arbitration Act as a whole. You've got to look at all the relevant sections when asking yourself, what does section 40 mean? And that involves looking back at section 33 and the sections between 33 and 39, but it also involves looking at section 41A and asking yourself, what would the purpose be if Parliament had thought in the 2025 Act that section 40 had these qualifying words in the sense that Mr Dunning suggests? It's left those qualifying words out of section 41A, thereby, as Mr Dunning, I think, was forced to recognise the logic of his own argument, that he accepts in the end, just about, that a peremptory order can be made by the emergency arbitrator, covering the same kind of ground as we've got here, and that can come to the court under section 42, and the court can make an order. If Parliament had thought that section 40 had these qualifying words, it would surely have included those same qualifying words or other suitable qualifying words in section 41A to apply to the emergency arbitrator, but it doesn't. Conclusion, that there are no qualifying words in the sense Mr Dunning uses. It's obvious why.
When you say Parliament, you mean Parliament in 2025?
Yes.
Not Parliament when enacting the 1996 Act.
Parliament in,
I mean, the stages are
Parliament in 2025.
1996 Act enacts section 40. We don't have a 41 and 41. We don't have a 41A.
That's right.
It means what it
It
means.
means what it means. And
2025, you say, Parliament then must have understood it to mean that those weren't qualifying words, because otherwise they'd have put the qualifying words in section 21A.
That's right.
But where does that get you on parliamentary intention?
Well,
Is it that we
claim.
don't need to worry what the Act meant before 2025? We only have to construe what the Act means with section 21A in it?
41 in it.
Sorry, 41A.
Well, you have to construe the Act with section 41A in it as of today to see what the Act means. My submission is simply this, that 41A being inserted in the terms that it is a powerful clue that Parliament at least didn't think there were qualifying words back in 1996 in section 40, subsection 1.
No, it doesn't tell you anything what Parliament thought in 1996. It tells you what Parliament thought in 2025.
And it's a reassurance that it didn't. And in fact, when you go to look at section 40 and 41 from 1996, they still mean what they've always meant. I'm not submitting that the 2025 Act has changed section 40
I understand.
at all.
We're just on the point of the extent to which section 21A helps.
So it's a reassurance for the court that my submissions are correct and Mr Dunning's are wrong. It may not take us very much further, but it would be an oddity, as the court pointed out to Mr Dunning, as we say in our skeleton argument. It would be very odd to create such a regime which gave the power to the court to deal with emergency arbitrators' peremptory orders, gave the emergency arbitrator the power to make a peremptory order, but didn't confer that power on the tribunal. And as the explanatory notes say, it's paragraph 30 that we looked at earlier, almost the first thing that a tribunal will do is to review the orders made by an emergency arbitrator. And to take my Lord's point about this week and last week, if the emergency arbitrator makes an order last Friday. The tribunal is then constituted next Monday. The tribunal will review those orders made by the emergency arbitrator. But on Mr Dunning's analysis, the court could have granted relief under section 42 in the interim period between the emergency arbitrator making his or her order and the tribunal coming on the scene. But once the tribunal comes on the scene, reviews the order, let's assume they uphold it, the powers of the court in section 42 are curtailed because, on Mr Dunning's analysis, unlike the emergency arbitrator, the tribunal itself doesn't have any power to make a peremptory order. And that would be a very curious set of circumstances. But on Mr Dunning's analysis, that's what's happened. Now, Mr Dunning's 9 propositions, in the end, come back to the first words of section 40, subsection 1, and to the paragraph of Lord Mancy's judgment in the AES case, which I'm going to come to. But before I do that, and I'm going to take this as quickly as I can, the critical words are section 42A, any order or directions of the tribunal. And we set out in our skeleton a number of cases, and I'm sorry there are probably too many cases in the bundle, dealing with what's meant by the word any. And I'm not going to show you all of them, I just want to show you a couple of them. Can we have, please, Iqbal and the Secretary of State for the Home Department, which is AB2, tab 2, page 433. Basic proposition, paragraph 33.
This is tab 17 in our books, I think. Second volume.
Second volume.
Tab 17
for
us.
I haven't got the same tab. Paragraph 33 is a relevant paragraph. So you give statutory language its ordinary and natural meaning in the context. And then, so that's the starting point. You give the language its ordinary and natural meaning, unless there's a good reason not to do so. So what does any order mean? In the Phillips case, which is at AB1, tab 1, at 52, the case starts at page 39. The Privy Council was concerned with the Trinidad and Tobago Summary Offences Ordinance. And at paragraph 39, Lord Morris said, quote,
So you're where?
Felix and Thomas.
First.
Yes, first volume of the authorities.
Yes.
Page
Tab
3. Starts at page
39.
39. Relevant passages at page 52, page 305 of the report. Should be sidelined in the hard copies. So, in any place were the relevant words. And Lord Morris said, to interpret any place as excluding all places except public places involves altering what's been enacted. Now, Mr Dunning's argument, of course, is that any order doesn't mean any order, it only means some orders. But where does he get that from?
He gets it from 41.1.
So he said, yes, but it's an unqualified 42A.
Well, don't we have to look at what any order means in 41.5 first?
I'm sorry, Lord?
Don't we have to look at what any order means in 41.5?
Yes.
Because that's where one finds the power at what we've been calling it stage 2
Yes.
of the tribunal to make a peremptory order.
Yes.
And the argument against you is that although it says any order, it takes its colour from 41.1, and the whole section is only dealing with things which are necessary for the proper and expeditious conduct of the arbitration.
Yes, I,
So that citing authority that you have to look at the meaning in the context doesn't take you beyond that. The context, he says, is 41.1.
yes, but the word in 42 is any order, and once the tribunal's made an order, compliance with the tribunal's order is part of the performance of the party's obligations. In
So do
section
you
40.
accept that the power in section 41.5, when it says any order there, is confined to failure to comply with orders that are necessary for the proper and expeditious conduct of the arbitration?
So I don't accept that. I
So
don't
isn't that the first question?
I don't accept that. It's a freestanding and broad power.
Right.
But if it's necessary, if it is necessary to be constrained by the words in 41A, then we're well within them in any event.
Well, I understand that. This is why I was putting to Mr. Dunning that there are perhaps three stages. One is that he's got to get home on 41.5 with
Yes.
any order meaning and being confined to one, which is an order for the proper and expeditious conduct of the arbitration.
Yes.
The second is that failure to comply with any order doesn't count as a failure to do something necessary for the proper and expeditious conduct of the arbitration within the meaning of 32A. And then third, that if he's right about that, these orders, or actually anti-suit orders in the abstract, are not capable of being necessary for the proper and expeditious conduct of the arbitration.
Right, well,
And I was only jumping in because you seem to be jumping in at stage 2, and I wondered whether you were conceding stage 1, but you're not.
No, I'm not conceding stage.
So we're looking at stage 1, we're looking at what's meant by any order
Yes,
in section 41.
yes,
And that has as its context that it is in a section which includes 41.1.
that's true. Yes.
What do you say the purpose of 41.1 is, if it is not, as Mr. Dunning suggests, to govern the whole section and to make clear that the whole section is dealing with orders which are necessary for the proper and expeditious conduct of the arbitration?
The purpose of section 40, subsection 1,
41.1.
41.1.
Yeah.
Can I just, I haven't got it in front, can we have 41.1 in front of me? Please, which is at page 801, AB 33801. I'm afraid my screens are kaput, my lord. I can't see the authorities.
I've got it twice, so let me hand you mine.
The danger of electronic bundles is that when the screens don't work, I'm essentially blind.
Can someone?
Would it assist if I give you this?
Thanks. So, 41.5. If without showing sufficient cause, a party fails to comply with any order, the tribunal may make a peremptory order to the same effect. So that's a very broad power.
Yes.
Conferring on the tribunal the power to essentially repeat its order in peremptory terms. 41.1, parties are free to agree on the powers of the tribunal in case of a party's failure to do something necessary for the proper and expeditious conduct of the arbitration. That's then followed by subsection 2, which says, unless otherwise agreed by the parties, the following provisions apply. So everything that follows in 41.3, 4, 5, and so on is conditioned by section 41.2, but the parties have got a free hand in 41.1 to agree what the tribunal's powers in case of a failure might be.
Given the width of section 38, what does 41.1 add? In what way would the position be different if 41.1 weren't there?
Well, 41(1) and 41 and 42 are looking obviously with the position of default, whereas 39, 38 and 39 are dealing with the general powers of the tribunal short of default. So it's just a specific provision elaborating. So you get 38 parties are free to agree on the powers exercised by the arbitral tribunal for the purposes of and in relation to the proceedings. And then they're further enabled in 41 to agree what the powers of the tribunal will be so there's been a failure to do so. So it's the next stage of the analysis. That's what it adds. It's dealing with different things. It's dealing with default as opposed to the general powers exercisable by the tribunal. It's a specific provision dealing with default. That's what it adds. Simple as that.
And you say that wouldn't be within the powers which Section 38
Well,
allows the parties to confer?
it might be belt and braces, it might be, but it's a specific provision dealing with default.
What 41(1) is dealing with is where the powers of the tribunal in the case of a party's failure to do something.
Yes.
And we know from 41 that a failure to do something necessary for the proper and expeditious conduct includes not complying with any order or directions. I'm not sure how that can inform what is the nature of, how that restricts what is the nature of an order or directions.
Well,
As Mr. Dunning suggested.
no, well, it's 41(5) is a very broad power, and 40 subsection 1 is simply saying that the parties have to do all things necessary for the proper and expeditious conduct of the proceedings. So the scheme all fits together, and the qualifying words that Mr. Dunning finds are not qualifying words at all. They're simply words which are explaining that once the tribunal is constituted, so Section 33 and so on deals with the powers of the tribunal. When we get to Section 40, the tribunal is constituted. And once the tribunal is constituted, it makes sense to impose on the parties an obligation to, as it were, behave themselves, because the tribunal is then constituted. And part of that is complying with orders made by the tribunal, Section 42.
Yes. I think the point I was making is one in your favour, which is that what is being suggested is that you have to interpret order or directions in 41(5)
Yes.
in the light of 41(1).
Yes.
But 41(1) is not dealing with
No, that's
the
right.
nature of order and directions. It is dealing with the powers of the tribunal if a party fails to do something necessary.
Yes, that's right.
And what we know qualifies for that is somebody who doesn't comply with order or directions.
Yes, that's right.
So it doesn't
Right.
doesn't
Well,
qualify order or directions at all.
I thought I'd made the submission to my lord a couple of minutes ago that 41(5) is not conditioned by 41(1). 41(2) says it is the key provision that in informing how you then read the rest of Section 41. But Section 41(1) and 41(5) are not. Well, 41(5) is not conditioned by 41(1). 41(5) is a very broad power where parties fail to comply with any order or directions of the tribunal. And that's what's happened here, obviously. Well, as I see the time, it's a couple of minutes past 1.
Yes,
I do need these screens to be.
yes, it's probably a convenient moment. 2 o'clock.
Court rise if able.
meeting. So I just need to get instructions. Yeah, I know.
Normally work off the hard copies anyway.
I still need to take instructions.
Yeah, I mean, yeah.
That's in the room that's having issues. So I think there's an issue with the chain, so I'm just going to sort it out now for you. Doing big I'll sort it out for you.
Yeah.
It's because no one's sitting here. Okay, I'll give you the stand from this one then. Sure. We'll come back in a second. So the one on
Does that mean when he said, do you mind if we have that on screen? I think he must have thought I hadn't been doing my job all morning.
No, they were wrong when we left though.
I know.
So I don't know at what point they
But when he said that, I was like, yeah. I was like, it's on screen. He was like, can we get that on screen? And I was like, oh my god, he's had no screen the entire time and just thought.
Did he not say that the screen was off?
He said, I haven't complained. But, well, he said, yeah, my screen's off. I haven't complained. I said, yeah, we were waiting for a transcribed break to come in and fix it. So we'll do it at lunch.
Yeah.
But
That
then
was just
when
that
he
one
says,
screen at the back. It was just that one that wasn't working. But
oh,
it wasn't these ones.
I think they can see theirs, I think. Because when he kept saying, can we have it on screen, the person behind him was like, I think it's on screen.
Oh, okay. I see. Oh, fun. Fun stuff to break.
Yeah. I can see why you don't like the RCJ now.
How long do you think it will take?
Hopefully 5 minutes. I just need to unplug all of them, let them reset and I plug them back in. Which is what I'm hoping it's doing right now. Just make sure the charges one is good. But yeah, I will be as fast as I can, I promise.
Thank you.
Because yeah, you need to get a break as well.
Yeah.
They're keeping you in here otherwise.
And you.
Yeah, I was sat out there all morning. I thought, oh, you know, I'll just sit out there till they break, it'll be fine. Okay. I was getting power.
Where do you normally go for lunch?
Hmm?
Where do you normally go for lunch?
I mean, normally I buy something or, yeah, there's like a Tesco across the road. For the RCJ, I never really worked at a DP, so I didn't have to do the lunches here. I only did it once. I was downstairs by the exit, so it's easy for me to get back quickly. Chained fine. It might be this. If it's this, that's a